How's everybody doing? Great to be learning with you on a Sunday night. Let's light up the darkness. Who's in the house? Stephen in New Hampshire, Bill in Mid-Missouri, Paul in the Great Northwest, Carla in Brazil, Bella in Florida, Shandora in the Bronx, Sharon in Massachusetts, Nancy in North Carolina, Chaim in Florida, Marjorie says shalom, Ella says shalom, Lynn in Maryland, and Rochelle in Modesto. Welcome, and Nancy in North Carolina. Welcome, everybody. Tonight's episode of AT Daily, sponsored by our own Susan Straus. Sue Straus in the house. In memory of my grandparents, Abraham Krisky, Toby, Tillie, Krout, Krisky, Edward Straus, and Sarah Straus. Edward and Sarah were cousins, so her maiden name was also Straus. May the neshamas have a great aliyah. May the souls have a great elevation in the world of souls. We say amen. And Susan, may you and all your loved ones be showered in blessings. We say amen. And thank you for enabling us to share more Torah with more people around the world. Excuse me. When the winds blow in LA, the dust kicks up and I get a little allergic. Okay, our daf tonight is page 45. And with this page, God willing, we're going to complete chapter 4 here in Tractate Bava, Kamma, the 21st volume of the Talmud. Relatively short daf. We're going to do 2 Mishnas 8 and 9, and finish the chapter. And we're going to keep it moving because Nina and I got to go pick up our daughter at the airport coming home from college. We're very excited. Mishnah number 8 here in chapter 4. With regard to an ox that is leaving court to be stoned for killing a person, and its owner then consecrated it, it is not considered consecrated, i.e. the consecration does not take effect, since deriving benefit from the ox is prohibited, and the ox is therefore worthless, right? Once the verdict has been reached, witnesses testify this ox killed a person, and the court judges it has to be put down, it has to be stoned to death, which basically means thrown off a cliff. Therefore, at that point, you can't do anything with it, right? But if you try to do something with it before the verdict is reached, then it's a different outcome. But first, after the verdict, if one slaughtered it, its flesh is forbidden to be eaten, and it is prohibited to derive benefit from it. But if its owner consecrated it before its verdict, the ox is considered consecrated. And if he slaughtered it, its flesh is permitted. If the owner of an ox conveyed it to an unpaid bailee, or to a borrower, or to a paid bailee, or to a renter, and it caused damage while in their custody, they enter, the bailee or the renter, into the responsibilities and liabilities that the owner would have if the owner was in possession of the ox. Therefore, if it was a muad, a forewarned ox, a habitual gorer, then the bailee pays the full cost of the damage as the owner would. And if it was an innocuous ox, a tam, then the bailee or the renter pays half the cost of the damage, just as the owner would. That's the Mishnah. Let's get into the Gemara. The sages taught with regard to an ox that killed a person, if its owner sold it before the verdict. Now we're actually on page 45a. it is considered legally sold and belongs to the purchaser for all purposes. Similarly, and since there was a change of ownership, right, if it was a muad, it is no longer a muad, as we learned earlier. Similarly, if he consecrated it, it is halakhically consecrated, and all the laws of consecrated property apply to it. Remember, consecration means you declare that this bull is no longer yours. It now belongs to the holy temple when the temple is standing. It's a donation that you make to the treasurer of the holy temple, so it can be used for the upkeep of the temple. So if he consecrated it, it is consecrated, and all the laws of consecrated property apply to it. If he slaughtered it, one is permitted to eat its meat. If a bailee charged with safeguarding it returned it to its owner's house before the verdict, it is considered to be returned, and the owner has no further claim against the bailee. And so it's very interesting, right? If this ox killed a person, but if before the verdict is reached, there's a change of ownership, it's going to have a change of status that will actually save the life of the ox. Now, by contrast, once its verdict has been issued, if the owner sells it, it is not sold, since the ox is no longer his. Similarly, if he consecrates it, it is not consecrated. If he slaughters it, its meat is forbidden. And this, by the way, this makes sense, right? Because this is all before the verdict is reached. So even in the case of an animal, we're not going to say that this animal is chayav misa, right? That it is liable to be put down, capital punishment for the animal, until witnesses testify to that and the judges render a verdict, as we'll see, in the presence of the ox, right? And until then, the ox is not, liable to be put down. It does not have a status of a convicted ox, as it were. And that's why it can be sold or consecrated, etc. But once the verdict has been reached, now the ox, nobody can eat it, nobody can benefit from it. The only thing that can happen to it is it receives its death penalty because it killed a person. Similarly, if he consecrates it, it is not consecrated. If he slaughters it, its meat is forbidden. If a bailee returns it to its owner's house, it is not considered to have been returned, since the ox is considered to have been killed. Rav Yaakov says, even once its verdict has been issued, if the bailee returns it to its owner, it is considered to have been returned. But that's a minority opinion. Remember, when a borrower borrows an ox, he has to return what he borrowed. So if, while it was in his care, it killed somebody and was convicted and had to be put down, the borrower is going to owe another ox to the person he borrowed it from. Now, the Gemara suggests, let us say that they disagree about this, right? Rabbi Yaakov and the majority. The rabbis hold that with regard to items from which it is prohibited to derive benefit, one does not say that which is yours is before you, and no compensation is required. Once the deposited item was rendered forbidden, the bailee, the one entrusted to care for it, cannot return it as is to its owner, claiming that since it has not been physically damaged, he has fulfilled his obligation to return it, and therefore the owner has no further claims against him. And Rabbi Yaakov holds that one does say, with regard to items from which it is prohibited to derive benefit, that which is yours is before you. Now, normally this phrase, that which is yours is before you, is used when a thief steals something, right? So now if he's brought to court and it's proven that he stole something, he has to make restitution, he has to return that which he stole, and he has to pay a fine on top of that to the person that he stole from. But if, before that verdict is reached, he says, there's your property that I took, it is now before you, he won't owe the fine because he returned it before he was forced to by the court. And here we're saying that, in the case of the borrower, if while it was in his care, the ox killed someone and now it is liable to come to court and receive a death penalty, but before the verdict is reached, he can return it to its owner and say, okay, I returned your ox. I don't have to find some other ox to return to you, which he would have to do after that ox, receives its death penalty, and then now no one can derive any benefit from it, including getting credit for returning the ox that you borrowed. Now, Rabbah said, and interestingly, Rabbi Yaakov says you can return it even after the death penalty is reached. But that's the minority opinion. Now, Rabbah said clearly, according to everyone, one says with regard to items from which it is prohibited to derive benefit, that which is yours is before you, as if this was the subject of disagreement, let them dispute this matter with regard to leavened bread on Passover, which is a more common case of an item from which it is prohibited to derive benefit, right? If you have any chametz in your house, any leavened bread, for example, once Passover starts, you cannot derive any benefit from that chametz. You can't even, give it to a goy. At that point, it can only be destroyed. And even if, you find it after Passover, when chametz is permitted again, you cannot derive benefit from chametz that was in your possession during Passover. Now, once something is prohibited for benefit, it means you can't get any benefit from it, including giving it to somebody and getting credit for giving it to someone. So rather, here they disagree with regard to the matter of issuing the verdict for an ox in its absence. The rabbis hold that the verdict for an ox can be issued only in its presence. That's the majority opinion. That's the law. And therefore, the bailee is not exempt by returning it after the verdict, as the owner could say to him, if you had returned the ox to me before the verdict, I would have smuggled it to the marsh, and the court would not have been able to sentence it to stoning. Now you have let my ox be seized by the court, with whom I cannot engage in litigation. So I'm out an ox. And Rabbi Yaakov holds that the verdict for an ox can be issued in its absence. Therefore, the bailee is exempt, as he can say to the owner in response to this claim, well, ultimately, they would have issued the verdict anyway, so I did not cause your ox to be stoned by not returning it to you before the verdict. So according to this explanation, what is the reason for the opinion of the rabbis that the ox's verdict can be issued only in its presence? The verse states, Exodus 21:29, the ox shall be stoned and its owner also be put to death, indicating that as the death of the owner, i.e. a person, for killing another person, so is the death of the ox for killing a person. And just as the owner is sentenced to death only in his presence, so too, an ox sentenced to death can only happen in the ox's presence. And Rabbi Yaakov holds that the owner and the ox cannot be compared. Granted, the owner must be present when the verdict is issued, as people are able to present claims in their defense. But as for an ox, is it capable of presenting claims? Consequently, it makes no difference whether or not the verdict is issued in the ox's presence. And that concludes that part of the discussion. Now, the Mishna teaches if the ox's owner conveyed it to an unpaid bailee. Now, the Mishnah said that if your ox is in the possession of an unpaid bailee and it causes damage, the unpaid bailee is in the place of the owner with respect to paying damages. And you're like, wait a minute, whoa. I understand if a borrower has my ox and it hurts someone, that he is liable to pay the damages. And I understand a paid bailee. If I pay someone to watch my ox and the ox gets away from him and it causes damage, then he should have to pay those damages. But the unpaid bailee seems a little counterintuitive. If I ask somebody to watch my ox for me as a favor to me, and then the ox causes damage, really? Now the unpaid bailee has to pay those damages? Don't you think maybe I should be on the hook for that, since the unpaid bailee was doing me a favor? Hang on to your hats. It's not so simple. So the Mishnah teaches, if the ox's owner conveyed it to an unpaid bailee, or to a borrower, or to a paid bailee, or to a renter, they enter into the responsibilities and liabilities in place of the owner. Now the sages taught there are 4 people who enter into the responsibilities and liabilities in place of the owner, and they are an unpaid bailee, a borrower, a paid bailee, and a renter. If the ox killed people while in the possession of one of these people, if the ox was innocuous at the time and it killed, then it is killed, and the bailees are exempt from paying ransom. If the ox is forewarned, it is killed, and the bailees pay the ransom. And regardless of whether they were innocuous or forewarned, the bailees are liable to return the value of the ox to its owner, with the exception of the unpaid bailee. So the sages said, wait a minute. Same question I just asked you. What are the circumstances in which the bailees are liable, with the exception of the unpaid bailee? So if he safeguarded the ox appropriately, but the ox killed a person anyway, all of the bailees should also be exempt from reimbursing the owner for the ox, and not just the unpaid bailee, as they did everything that was required of them. And if he did not safeguard it properly, then even the unpaid bailee should be liable, as he was also required to safeguard it. Okay. So, not so quick. If whoever had possession of the ox, whether a renter, a paid bailee, an unpaid bailee, or a borrower, if he properly safeguarded the ox, he's not going to be liable to pay the damages. It will accrue to the owner. It's only if they were negligent. And yet, we still have a distinction between the unpaid bailee and the others. So what's going on? So the sages said in response, here we are dealing with a case where the bailee provided reduced safeguarding and did not provide superior safeguarding. So in this case, the unpaid bailee has fulfilled his safeguarding duties. Since he does not receive anything in exchange, this level of safeguarding is sufficient. But those other bailees who have a greater responsibility because they're a borrower or they're getting paid or they're renting, they have not fulfilled their required level of safeguarding with minimum degree of safeguarding. They need proper safeguarding. So the sages said in clarification of the Baraisa, in accordance with whose opinion is this Baraisa? If it is in accordance with the opinion of Rabbi Meir, who says that a renter is considered like an unpaid bailee with regard to his responsibility for the rented item, let it teach that bailees are liable to compensate the owner with the exception of the unpaid bailee and a renter. Since it didn't say that, it must not be in accordance with Rabbi Meir. Now we're on page 45b. And if the Baraisa is in accordance with the opinion of Rabbi Yehuda, who says that a renter is considered like a paid bailee, well, then the Baraisa should have taught with the exception of an unpaid bailee, as it in fact states, but it should also state that in a case where the oxen are forewarned, all of them are exempt with regard to ransom, as Rabbi Yehuda says in the next Mishna that a forewarned ox requires only a reduced level of safeguarding. Well, so therefore this Baraisa does not appear to be in accordance with the opinion of either Rabbi Meir or Rabbi Yehuda. So Rav Huna Bar Chanana said, in accordance with whose opinion is this Baraisa? It is in accordance with the opinion of Rabbi Eliezer, who says that an ox has no sufficient safeguarding at all, other than slaughtering it with a knife. Now, as we'll see, he says that with regard to the muad, right? The muad is the forewarned ox who has gored in the past, and if we're saying he's forewarned with respect to killing, well, and then for whatever reason there weren't witnesses to testify or whatever, that is a very dangerous ox. So Rabbi Eliezer is saying if you have such a dangerous ox, there is no level of safeguarding that is adequate for it. There are no iron doors that are sufficient to enclose it in the barn. You should just kill it so that no blood will be on your hands if it gets out and kills somebody. I.e., there is no degree of safeguarding that exempts the ox's owner, or in the context of the Baraisa, the bailee from liability if the ox causes damage or kills. And with regard to a renter, the Baraisa holds in accordance with the opinion of Rabbi Yehuda, who says that a renter is considered like a paid bailee. So Abaye said, no. Actually, the Baraisa is in accordance with the opinion of Rabbi Meir. And it is, as Rabba Bar Avu reversed the two opinions and taught, how does a renter pay? In other words, what is his degree of responsibility? Rabbi Meir says, like a paid bailee. Rabbi Yehuda says, like an unpaid bailee. That was Rabbi Eliezer. Rabbi Elazar says, if the owner conveyed his ox to an unpaid bailee, if the ox causes damage, the bailee is liable to pay damages. But if the ox was injured, he is exempt. And the sages said, what are the circumstances? If Rabbi Elazar was referring to a bailee who accepted responsibility upon himself for guarding it from causing damage, even if the ox was injured, he should be liable. And if he was referring to a bailee who did not accept responsibility for guarding it from causing damage, even if it causes damage, he should be exempt from payment. So Rava said, actually, Rabbi Elazar was referring to a case where he accepted responsibility upon himself for guarding it from causing damage. But here we are dealing with a case where the bailee recognized that the ox was a goring ox. And in that case, the normal way of things is that the bailee accepted upon himself responsibility for safeguarding it so that it would not go and injure others, since he knew that it was dangerous. But it presumably did not enter his mind that other oxen would come and injure it. Therefore, he did not accept responsibility for safeguarding the forewarned ox against being injured by other oxen. And that concludes our discussion of Mishnah number 8. Here's Mishnah number 9, the final Mishnah of our chapter. If the ox's owner tied it with reins to a fence or locked the gate before it in an appropriate manner, right? So an appropriate manner. But nevertheless, the ox emerged and caused damage, whether the ox is innocuous, a tam, or forewarned, a muad, the owner is liable, since this is not considered sufficient precaution to prevent damage. And this is the statement of Rabbi Meir. You might have thought, okay, the ox has reins. I tied the reins to a post. I thought I was covered. But the ox, very strong, it could easily knock over the post, get free of that, and go and cause damage. That was not adequate. Closing a gate, not adequate. Why is it not adequate? Because an ox has a lot of strength. A lot of strength. It could break through any gate. It could break its reins. You can't say that because you tied it up or closed some little gate in front of it that it was adequately safeguarded. It wasn't adequately safeguarded. Rabbi Yehuda says that if the ox is innocuous, the owner is liable even if he safeguarded it appropriately. And you're like, wait a minute. It should be if it was a forewarned ox, he is liable even if he safeguarded it appropriately. Why are we going to say if it was an innocuous ox with no history of goring, that the owner is liable despite the fact that he safeguarded it properly when the ox nevertheless got out and caused damage? What's the reason? Since the Torah does not limit the required safeguarding for an innocuous ox. In other words, when the Torah talks about that if your ox goes and gores somebody else and you owe half damages, that's an absolute liability. Doesn't matter what safeguarding you did. The liability is limited to half of the actual damages and no other penalties or fines. That's because it's an innocuous ox. And so you're going to have to pay that no matter what kind of safeguarding you did. But if the ox is forewarned, right, it has a history of goring, then the owner is exempt from paying compensation for damage, presumably if he safeguarded it properly, as it is stated in the verse describing damage by a forewarned ox, Exodus 21:36, and the owner has not secured it. And this ox that was tied with reins or behind a locked gate was secured, according to the opinion of Rabbi Yehuda. Rabbi Eliezer says an ox has no sufficient safeguarding at all other than slaughtering it with a knife. There is no degree of safeguarding that exempts the owner from liability. That's Mishnah number 9. Here's the Gemara. What is the reason for the opinion of Rabbi Meir? He holds that ordinary oxen are not presumed to be under safeguarding, as their owners do not ordinarily safeguard them. And the merciful one stated in the Torah that one will be liable even for damage caused by an innocuous ox, inasmuch as it requires at least a reduced level of safeguarding, such as with reins. And the merciful one then stated with regard to a forewarned ox, and the and the owner has not secured it, to indicate that it is not sufficient to provide it with only a reduced level of safeguarding, as it requires superior safeguarding. And Rabbi Meir derives this requirement with regard to an innocuous ox from a verbal analogy between the term goring, stated with regard to an innocuous ox, and the term goring, stated with regard to a forewarned ox. In both cases, superior safeguarding is required. Otherwise, the owner is liable. So at least by Rabbi Meir, if you did the superior safeguarding, you're not going to be liable. So by contrast, Rabbi Yehuda holds that ordinary oxen are presumed to be under some reduced level of safeguarding. And since the merciful one stated nevertheless that even for damage caused by an innocuous ox, the owner will pay, it may be inferred that it requires superior safeguarding. And the merciful one then states with regard to a forewarned ox, and the owner has not secured it, emphasizing again that one must provide it with superior safeguarding. And this constitutes one amplification following another amplification. And our principle of hermeneutics, of deriving laws based on amplification followed by an amplification, is stated, meaning that the Torah stated an amplification followed by an amplification only in order to restrict its extent. Accordingly, the verse excludes the requirement of superior safeguarding with regard to a forewarned ox, and therefore reduced safeguarding is sufficient to exempt the owner from liability. That just seems so counterintuitive, and maybe that's why Rabbi Yehuda lost that battle. And if you would say that through the verbal analogy between the term goring stated with regard to an innocuous ox and the term goring stated with regard to a forewarned ox, the Torah compares their laws, and nevertheless the merciful one restricted this law by emphasizing, and the owner has not secured it, referring specifically to it, the forewarned ox, and not to the other, the innocuous ox. So the Gemara asks, but isn't this phrase necessary for the negative statement that if the owner does not provide superior safeguarding, he is liable? And the Gemara answers, if that is so, let the merciful one write, and the owner has not secured. What is the purpose of the added emphasis, and the owner has not secured it? It is to indicate that the restriction of this law relates specifically to it, a forewarned ox, and not to the other, the innocuous ox. So it is taught in a Baraisa that there is a fourth opinion. Rabbi Eliezer ben Yaakov says, in the cases of both an innocuous ox and a forewarned ox, in which its owner provided reduced safeguarding, he is exempt from liability. Any safeguarding will do. And the Gemara asks, what is the reason for this opinion? Well, he holds in accordance with the opinion of Rabbi Yehuda, who says that reduced safeguarding is sufficient for a forewarned ox. And he derives from the verbal analogy between the term goring stated with regard to an innocuous ox and the term goring stated with regard to a forewarned ox, that just as reduced safeguarding is sufficient for a forewarned ox, it must be sufficient for an innocuous ox. Rav Ada bar Ahava said Rabbi Yehuda deemed only the forewarned element of the ox exempt. Rabbi Yehuda's ruling that reduced safeguarding is sufficient to exempt the owner of a forewarned ox relates only to the additional half of the damage that is paid for a forewarned ox beyond the half damages that one is liable to pay for an innocuous ox. Rabbi Yehuda doesn't excuse you from that, but the liability for its element of innocuousness remains in place. Therefore, if the owner did not provide superior safeguarding for the forewarned ox, he is still liable to pay half the cost of the damage as he would if it were an innocuous ox. Rav says, if an ox is forewarned with regard to goring with its right horn, it is not thereby forewarned with regard to goring with its left horn. The sages said, in accordance with whose opinion is this statement? If it is in accordance with the opinion of Rabbi Meir, doesn't Rabbi Meir say that both an innocuous ox and a forewarned ox require superior safeguarding? If it is in accordance with the opinion of Rabbi Yehuda, why did he state that the ox still has an innocuous element specifically with regard to the left horn, even with regard to the right horn itself? It has both elements. It has an element of innocuousness and also an element of forewarned. So the sages said, actually, Rav's statement is in accordance with the opinion of Rabbi Yehuda, and he does not hold in accordance with the opinion of Rav Ada bar Ahava that the ox's innocuous element remains, and this is what he is saying. You find an element both of innocuousness and of a forewarned status in the same ox, specifically in a case like this, where an ox is forewarned with regard to one horn, but not with regard to the other. Now, this would assume that it always gored with one of its horns and not with the other, and that the owner was warned, yeah, your ox gores with its right horn. Now, this is definitely in the realm of the hypothetical, because no court would do that. They would just say, your ox gores. They wouldn't limit it, right? But if they had limited the warning, then this result would ensue. Now we're at the top of page 46a, and I'm almost done. So if you've got questions or comments, please get them in. But if an ox is entirely forewarned, you do not find an element of innocuousness with regard to it at all. If it is forewarned with regard to goring with either horn, its status of innocuousness is completely revoked, according to that opinion. Now, the Mishnah teaches that Rabbi Eliezer says an ox has no sufficient safeguarding at all other than slaughtering it with a knife. And Rabbah said, what is the reason for the opinion of Rabbi Eliezer? It is, as the verse states, with regard to a forewarned ox, and the owner has not secured it. Meaning that once it is rendered forewarned, the owner no longer has any sufficient manner of safeguarding this animal, and the owner is responsible for all damage that it causes. You can't say that you took some safeguard precautions and then you're going to escape liability. Once it's a muad, it's your ox. If it causes damage, you're on the hook for full damages, and the injured party has recourse to all of your property for that. And Abaye said to Rabbah, whoa, if that is so, does that which is written with regard to a pit, and if a man shall open a pit, or if a man shall dig a pit and not cover it, also mean that once a pit has been dug, the owner no longer has any adequate way of covering his pit, which would exempt its owner from paying damages? No, because we will discuss in the next chapter in the laws of the pit that if you cover it and you cover it properly, then you are no longer liable. And if you would say that indeed this is the law, but didn't we learn in a Mishna on page 52a that if he covered the pit appropriately and an ox or a donkey fell into it and died, the owner, the one who dug the pit, is exempt. So evidently a pit can be covered adequately. So rather, Abaye rejected Rabbah's explanation of Rabbi Eliezer's opinion and said that this is the reason for the opinion of Rabbi Eliezer, as it is taught in a baraisa that Rabbi Nassan says. From where is it derived that one may not raise a vicious dog in his house, and that one may not set up an unstable ladder in his house? As it is stated, you shall not bring blood into your house, which means that one may not allow a hazardous situation to remain. Not only in the public domain, you can't create a hazard, you can't even allow a hazard to exist in your house. And similarly, a person should not keep a forewarned ox in his possession, as it is dangerous. And this is why Rabbi Eliezer rules that no level of safeguarding is sufficient for it. The ox should be slaughtered so that it will not cause damage. That's what I've got for us today. Nina's telling me no questions. So that concludes chapter 4. And with God's help, tomorrow, Monday at the regular time, 6 p.m. Pacific, we will open chapter 5. We'll do a little bit more with the ox, and then we'll move into the laws of the pit. Have a great night.